Folks, it's nice to see you here. I know Rich did a great job this morning. I'm Dan Grable. Please call me Dan. I work for Ernst & Young, and as Rich told you, we've been a partner with the FRS, gosh, for a long time now, actually since 2002, and there are two big reasons that you like us already. One, we're totally objective on any information we give, and number two, Ernst & Young sells nothing. We don't sell life insurance, no mutual funds, no investments, don't want to do your taxes, don't market anything. Safe, confidential, objective resource provided to you by your Florida retirement system. And I know Rich talked a little bit about this, but there's two things that we do for the FRS. A lot of people think we manage the investment plan, and I know he told you we don't do that, and that's absolutely true. We don't manage any money at all. We do workshops, and we do about 350 days of financial education workshops around the state, and I'll tell you in a minute on the website where you can see that list, and we provide the financial guidance line that I'll be talking about in just a few minutes. And handout-wise, you should have several things. One is that survey or evaluation form in your packets. Is this echoing too much? Is that okay to y'all back there? It's weird to me up here. But you have that evaluation form. Afterwards, please give us a little feedback if you have time. But if you run out of time, don't worry about it. The bigger handout has copies of the slides we're going through. Please follow along, make a few notes. And if you would go ahead and start thumbing through that from the front, you'll see two slides to a page. Page number's bottom right. I'm looking for page 17. It's about in the middle. It has the last couple of slides on it, and then the next page is a table of contents for appendix pages. Then the next few pages is notice to employees, kind of the legal stuff, and you finally get to page 7 in the appendix in the back, and that is how much will my survivors need? If you passed away today, what would you want to leave behind for those loved ones? And then the next page is a sample healthcare directive, a sample living will. I'll be talking about this in a few minutes. The next page is a designation of healthcare surrogate. I'll talk about this one in a few minutes. The next page, what is my estate worth? I'm going to talk about two types of taxes. Income taxes that you're probably already way too familiar with, but then there's that other tax called the estate tax, or inheritance tax, death tax, transfer tax. And that's the tax that when you pass away, the government adds up the value of everything you own. And if you own too much, they would like to tax it one last time. And the tax rates are atrocious. They start at about 40%. But there's several pieces of good news for you. One, between a husband and wife, there is no estate tax. That means if I died today, and whatever I leave to my wife, there's no estate tax. She dies, leaves it to me, no estate tax. But when the second one of us dies and the money goes to our kids or someone else, that's when this potential tax kicks in. But the second piece of good news is there's a free limit or a free amount we can give away and not pay estate taxes on that amount. And it's dramatically gone up over the last few years, and that free limit now is a little over $5 million. That means I could leave $5 million to the kids. My wife could leave $5 million to the kids. That means the only problem I have is I don't have an estate tax problem. I finally find a tax I'd like to pay a little bit of, and I just don't qualify for it. But so we'll talk a little more about that as we go through. But most of you, as I went through that, said, I don't have an estate tax problem. I don't need to do that form. But this is a real important form because when you get to the lawyers and start doing your wills or trust, you need a real good list of your assets and liabilities so you can talk about how do I get this to my son, get this to my daughter. The next page there's actually several pages of what we call a vital record keeper. I'll talk about this in a few minutes, but just kind of know where that is. And then you finally get through that. There's a page that says financial guidance line appointment. I'll talk about this, know where this is. And then finally, the page that has all the lines on it, that's your action plan or do list. As we go through this, you're going to think of a lot of things to do or think about or decide on. And if you're like me, if you don't get it on a list, you just won't get it done. So use that as your do list. And since we're in a workshop about estate planning, there's a real good chance that probably about half of you have not gotten around to doing your wills and trusts and things like that. And I don't think it's because you said you don't want one. I think it's because you just kind of haven't figured out how to get started, and that's my job today. But if you are one of those that haven't gotten around to doing that yet, I hate to break this to you, but if you're in this workshop, chances are you're closer to the end than you are the beginning, which means you may not be able to put it off much longer, which means the first thing on your do list maybe should be get a will. Then the little cards, one side of the card reminds you of the website address, myfrs.com. And you can look at a lot of info on that website without a PIN number. But to look at your numbers, pension or investment plan, or run the programs you need, your PIN number. And all of you were sent one. But if you've lost it, don't give it a second thought. You can flip the card over, call that guidance line number, hit option 1 or 2. They'll throw a new PIN in the mail to you. Or you can actually go to the website and start the login process as a new user, and it will determine you don't have a PIN number. It will request one for you. Regardless of how you request it, they're going to mail it to you, to your address of record in the FRS system. Not email it, but mail it. And I'm told they do that as another layer of security. I want your questions today. We'll try and take a few questions as we go through, but then I think we've got 15 minutes blocked out at the end for questions also. And there's a good chance I don't know all the answers, so I'll refer you to the right resource. If you get ahead of me, don't get your feelings hurt. If I say I'm headed there in just a minute, will you hold on to that question? And understand, too, as we talk today, I'm here giving you what we call financial guidance. I am not giving you legal advice. And as we go through this, it's my goal to motivate you to take action. I am probably not telling you everything you need to know to do all of your documents, but I'm kind of hitting the high spots, the basics, and real good chance you'll say, well, I need the rest of the story about that. And that means you can call the financial guidance line, and they will talk with you about these things, but they're not doing your documents for you either. But my goal is to motivate you and get you to take action and kind of get you started with this. So it's kind of a 2 or 3 stage process. Hopefully I get you to this point, and then either the lawyers or the guidance line or somebody will take you the rest of the way there. Okay, well, let's get started. It's a little strange. I'm here from your Florida retirement system. I'm not exactly talking about retirement, but that's okay because successful retirement planning includes planning for all aspects of one's financial life. We're going to learn a process for estate planning. We'll talk about the tools and resources available to help you, and hopefully you'll have some things on your do list or action plan to move you to the next level. All the resources I'm about to talk about are yours, whether you chose to be in the FRS pension plan or investment plan. It does not matter. On the left-hand side is the website, myfrs.com. Has everything about pension, investment plan, drop, health insurance subsidy. It's got a link to that division of retirement website. This is where the choice service is, where hopefully all of you went to run your numbers to compare the 2 plans. There's an area called second choice election. Hopefully all of you are in the perfect plan forever, but always remember you can change your mind one time. That's called your second choice election. And there's an area on the website you can look at the numbers and compare the cash flow. There's an advisor service on the website. One of the other things I'm pushing you to do is to run a retirement plan. And you can run that retirement plan yourself on the website, or you can just call the guidance line and they'll do it for you. Another cool thing on the website, toward the top right-hand corner, there's a red box called Hot Topics. And that's one of the places where the FRS communicates with you. Right now, I think there's 5 or 6 bulletins or reports out there. And when your elected officials are in session, one of those bullet points, the top one generally, is proposed legislation. And they update that every night. A lot of people get in the habit of punching that button every morning. What are those people talking about doing to my retirement? So even if you're not even going to be a serious website user, then at least go to that website and wander around from time to time. Then the next resource there is the financial guidance line. And this is the phone number that shows up on the cards. It shows up on every slide. And you dial that number and hit 1 or 2, you go to the EY Financial Planners. And they're there for all your financial questions, FRS and otherwise. FRS-wise, things like, what plan am I in? What will my benefit be? This is the day I started. When am I eligible for drop? Can I defer it? Should I defer it? Should I go into drop at all? I'm coming out of drop. If I take 50 grand out, what would the income taxes be? But all that FRS stuff, including income tax questions, estate planning, cash and debt management. But this is like having your own CPA and financial planner for free. And they don't sell anything. They don't market anything. It is a wonderful, safe, confidential, objective resource from your Florida retirement system. And they will talk to you as long as you want to on any financial subject, and you'll be dealing with the same planner. It's not a deal where every time you call in, you start over explaining the same thing to a new person. That just drives you bonkers. No, when you call in the first time, that's your planner. You'll get to know them. They'll get to know you. They'll follow up with you. You'll get reports. Just a neat resource. And this is the only place you'll find good planners that aren't trying to sell you stuff or charge you a fee. Real neat resource from your FRS. So take advantage of that. I'll talk to you in a few minutes on kind of a lot of different ways to contact them. Then the next resource there, workshops. I mentioned earlier we do 350 to 400 workshop days around the state. When you go to the website, kind of toward the top middle, there's a workshop button. You hit that, it tells you the 10 or so subjects we cover and gives you the schedule, which means if we're not going to be at your agency anytime soon for a particular subject, then you might find me 5 miles away at another agency, catch it there. We do webinars 2 days a quarter, 2 workshops each day. You can sign up and view those live on your computer. But if none of that works for you, when you look at the list of workshops on the website, most of them have a recording of a session. You can hit the button and watch that recording whenever you would like. Some things on your action plan. Maybe get a will, maybe get a PIN number, maybe starting to put some numbers on that asset and liability sheet. So we already have several things on there. Let's take a little test. Let's see what you know about estate planning. True or false? Estate planning is only important for wealthy people. False. Okay, good. Estate planning is only important for old folks. False. Good. Joint ownership of property makes having a will unimportant. False. And then spouses automatically inherit everything. You bet that's false. Okay, you're all pretty much experts. This won't take very long. We'll get away quick for lunch. Okay. All right. What does estate planning do for you? I'm going to use this as somewhat of our agenda today. But the first thing estate planning does is distribute property according to your wishes. But estate planning starts with a will. And with a will, you get to make your wishes legal, and you're doing this to help your heirs through a difficult time. We do not do estate planning for ourselves. We will be dead. We will not care. We do estate planning because we love the people we leave behind. If you've ever had a close family member die, and when they passed away, they left their affairs in a mess. There was no will. You didn't know where anything was. The desk was piled that high, deep in papers and stuff. It was a nightmare for the people left behind. I mean, they were hurting enough because mom or daddy or somebody passed away, but then they've got to deal with this mess they left behind. So we do estate planning because we love other people. But with estate planning, with a will, you get to document who will receive your property when you die. Name guardians for the kids. If any of you have young kids at home, should you and your spouse pass away without a will, then a judge would decide who will raise your kids. You don't want a judge to decide that. You want to make that decision. And those of you, probably several of you, that are old enough to have their own kids, your kids have their own kids, there's a decent chance that your kids don't have a will either. That means you're liable to end up begging some judge to have input in who will raise your grandkids. That means while you're trying to get your affairs in order, why don't you drag the kids along with you and get at least the basics done for them to protect those grandkids. And a will also appoints a personal representative, and another term for that is executor. We'll get to that shortly. How does property get from one person to another? When you pass away, how does your stuff actually get to another person? There's only two big ways that happens. One, it will either go through your will or transfer automatically. And by automatically, that could either be a beneficiary designation, contract, or joint ownership. But a real important point here is anything that goes through your will goes through probate. Anything that transfers automatically avoids probate. And I'm jumping ahead to talk about probate for a minute, and then I'm coming back to that slide we just left. But probate, that's the processing of your will by a special court, and if you pass away without a will, then the judge will appoint a personal representative for you, maybe an attorney or CPA being paid by the hour, but the courts will supervise distribution of assets, paying debts, handling personal affairs. This is the closing out of the estate. I actually live in Alabama, and I'm told probate there is probably about 6 months on average, give or take. I'm told in Florida it's a little longer, maybe average 6 to 9 months. I do a few workshops in Texas, and in Texas, probate's about 15 minutes and $25. In Texas, nobody does anything to avoid probate because it's so easy. But if any of you have family in New York or property in New York, probate's a nightmare up there. Could easily be a 2-year affair. So most of us would like to avoid probate if at all possible. Takes a little time, costs a little money, but it's not all bad. I'm painting it to be a negative picture, but it's not all bad. It is closing out of the estate. We're going to transfer ownership of the property. The creditors have to come forward. Another negative to probate is it's public information. That after you pass away, all your stuff that goes through the will, I can go to the courthouse and I can know all of your business. Now, for some of us, that's more important than others. I mean, I'm pretty much like, I think a lot of us, I really don't have very much. I mean, I got a little property, I got a little money, I got a little retirement money. And if you knew my business when I when I pass away, it's not that important. I mean, my stuff goes to my family and my church. And if you knew that, it's just not a deal breaker for me, but there are a lot of family situations that we would like to maintain some privacy. But probate is not private, it's public information. So we would generally like to avoid probate if at all possible. All right, I'm back to that other slide. If you own property individually, then when you pass away, they will look to your will to see where that goes, and it will go through probate. What if you own property jointly with a spouse? I own my home jointly with my wife. Joint tenancy will right of survivorship. That means when I pass away, then my half the house immediately goes to my wife. She passes away, it immediately goes to me. That means I've got a contract with my wife, and that is an automatic, immediate transfer. That means it would not go through probate. You can also have property jointly owned and and still have it go through probate. No, have it jointly owned and avoid probate just in family issues. And my wife has 3 sisters. If her dad gave the old family farm to the 4 girls, then he would title it jointly between the 4 girls. Because when my wife dies, he wants me having nothing to do with that. He would want it to stay within the remaining girls. So again, that's an automatic transfer, and that would avoid probate. But you could own property with someone and have it go through probate. That's called tenancy in common. If I bought a house to remodel with my buddy Steve, Well, when I pass away, I don't want Steve and his wife getting my half the house. I want it to go to my wife. That means we would title that tenancy in common, which means look to the will. The will says give it to my wife, but it would go through probate. Let's talk about retirement plans. Your drop account, your investment plan, your 457 deferred comps, 403B TSAs, 401ks, IRAs, Roth IRAs, all those kinds of retirement accounts have beneficiary designations on them. And some people have my estate or the estate or the estate of as a beneficiary. If you have done that, what you're saying is, I have a will. Look to my will to see where this stuff goes. And if you've got a current will, that doesn't sound bad, right? Well, wait a minute, though. That means it needs to go through probate. So it may be 6 months or so before anybody gets that money. The other reason why people generally don't have their estate as a beneficiary is you foul up the tax advantages. If I leave my IRAs, whatever kinds of accounts like that, directly to my wife, she maintains the tax advantages. She can have those IRAs turned into her IRAs, or she could keep them in my name with her, the owner, but maintains that tax deferral. But if I leave my IRAs to my estate and they go to my wife, all the taxes are going to have to be paid quickly. So that's another reason we typically don't have those things going through our estate. Most people have named beneficiaries. I would always have a contingent beneficiary. Sometimes the forms may not have a place for a contingent beneficiary, but you may just need to request another form or something. But mine go to my wife, and then if she and I pass at the same time, I've already got a second choice named. You can leave money to kids or to multiple people. You could leave half to one kid, half to another. I would suggest you always use percentages. Don't use dollar amounts. If you leave $10,000 to one kid, 10 to another, then you've probably got 19 or 21 in there, and you've just kind of slowed up the process. Be careful about leaving money to young kids. Understand, kids under 18 really can't own money. If you leave stuff to them, you've kind of thrown it into the court system. I'll talk a little bit more about that when I hit on trust and guardians in a couple of minutes. But usually you want those accounts going direct to named beneficiaries. And be careful about conflicts. It's real common to run into someone. One place you see this a lot, if you've got a bunch of kids, if you're doing a beneficiary form, splitting things up, then by the time you have to write down names and addresses and dates of birth, it takes forever to do these beneficiary forms. It's very common for someone to have one of the kids as their beneficiary. And their thought is, but my will straighten that out. I just did that for that form. My will says split it between all the kids. Well, the will won't straighten out anything. Typically, when there's a conflict between the will and one of these automatic things, the will always loses. So be careful about that. Another place you might see that is I might own my home jointly, maybe with my second wife, but my will might say give the old family home to my son from my first marriage. So we've got a major conflict there. The will's going to lose. My second wife is going to end up with that house. So be real careful about those conflicts. Another thing too, let's see, your bank accounts. Some of you may have someone else's name on your bank accounts, brokerage accounts, all those other kinds of accounts. And you've probably done it for two reasons. One, well, if something happens, I'm in a car wreck, in a coma or something, somebody can write a check, pay a bill, things like that. Or you're concerned about when you pass away, that stuff go immediately to somebody. Well, the problem of putting other people's names on those checking accounts and other types of accounts is you just gave them that money. Have you heard of lawsuits, divorces, things like that? The money in your checking account might have just gone to that evil ex-son-in-law you hated since the day you met him. I wouldn't have other people's names on those accounts. It's just too dangerous. If your idea is you want somebody to get that money immediately when you die, then you do that by beneficiary designation, or sometimes the banks call it a transfer on death. And if your idea is to let somebody write a check, if you are in a coma, Alzheimer's or something, you handle that by durable power of attorney. So it's just too dangerous having people's names on those accounts. In my family, there was Uncle Jess. And Uncle Jess didn't get married for a long time. And he always had his brother Tom's name on everything he had. Then Jesse finally got married. And he added his wife's name to everything, but he left Tom's name on there also. 15 years later, Jesse had a head injury, and they weren't sure that he was going to make it. Tom went down, sucked all the money out of all the accounts. And the wife didn't find out about it until she started getting notices and rubber check kind of thing. And she's screaming at the bank, knowing they got a lot of money, only to find out Tom took all the money. And the family got on him, and he gave it all back. But when asked why, Tom said, well, he's only been married to her for 15 years. Surely he didn't want her to have any of that money. So be careful. Families are kind of strange from time to time. But I'd be real careful about having other people's names. In fact, you could foul people up if you put your kid's name on there. Then if your kid's trying to get some kind of government benefits, your assets may foul up the kid. Be careful about putting your mama's name on your accounts, because that could foul mama up for those Medicaid nursing home type benefits down the road. So I wouldn't have other people's names on those accounts. If you're bound and determined to let a son write a check, set up a separate account and put $500 or $1,000 in it or something like that, so you don't have your major assets at risk. If you are starting to make asset transfers, if your parents are still around, then you may be trying to make them look broke so the government will pay for their nursing home care. Be real careful when you start transferring assets out of mama's name. I mean, you could cause yourself an income tax nightmare. I wouldn't do those kind of transfers without talking to a tax advisor. And be careful with things like cars. I mean, it's real common to take a car out of mama's name and have it in your name. My mama's got Alzheimer's now. She's had it. She's been in a care facility for about 6 years now or so. But when mama was still on her own and doing well, I bought her a new car, and we traded in her old car. And as we do the paperwork, I've got the paperwork showing mama as the owner of the new car. I'm going to write the check, but mama's going to be the owner of the car. And the dealership takes the paperwork in the back, and they did whatever they do in the back, and they brought the paperwork out. They'd added my name to it. And then I tore it up, said, no, we need to start over. My name isn't going to be on there. And then the sales guy says, oh, you need your name on there. You'll be able to do the tags and all that. And your mama dies, you immediately get the car. You need your name on there. I said, have you seen the car we're trading in? And the guy gives me this real dumb look, says, well, I drove it. And I said, did you notice the fenders, that all 4 fenders have dents in them? I said, my mama runs into things, and I'm not going to be associated with the liability of my mama running over somebody. And we laugh about that, and that is funny, there's no doubt. But I've got an aunt, I had an aunt in Arkansas, and my aunt was driving, had her sister in the car. My aunt caused a wreck that killed her and 2 people in the other car. And about a year later, I talked with my cousin Mac, and just in conversation, hey, everything work out okay with that wreck? And he said, yeah, I guess so. Said they took everything mama had. They took house, car, insurance. They took every nickel they could find. He says, I'm just so happy my name was not on that car. So be real careful about having other people drive cars. If you've got those 40-year-old kids with bad credit and you're co-signing cars, your kid runs over somebody, your financial life is over. So wouldn't have my name on those things. But if you just have to do that, then you might want to talk with your property and casualty agent about maybe jumping that umbrella policy another $1 or $2 million or something like that. But be careful about that stuff. I mean, I've got a handful of friends that their kids driving cars in mama's name. that have caused major problems like that. I mean, it happens all the time, so be real careful about that. Let's talk about trust. And I don't have a separate slide for trust. Everything's kind of right here. But two major types of trust I want to talk about. One, irrevocable trust. Number two, revocable trust. Irrevocable trust means when I set it up and I put something in it, then I have given it away. I do not own it anymore. And people generally use these irrevocable trusts to reduce estate taxes. If I had a fair amount of assets and I knew over the rest of my life they were going to grow, and at some point when I die, I'm worried about having an estate tax problem. Well, to combat that, I might say I'd like to go ahead and give some stuff to the kids today. But the only problem that if I give it to them today, they'll probably blow it in about 30 minutes. Instead of me giving that stuff directly to the kids, I would set up this irrevocable trust and put the stuff in there. And I would be the trustee, so I am managing it. The kids are the beneficiary, but they have no power or control over it until I actually pass away. That means people typically use these irrevocable trusts to reduce estate taxes. Revocable trusts, you'll sometimes hear them called revocable living trust, and it's hard to pick up a newspaper or financial magazine without seeing an article on these. And a couple of ways that these are typically used. One, when you are setting up your estate, you're probably going to have everything possible going direct to named beneficiaries to avoid probate. But then there'll probably be a few things left over that will go through your will. Maybe a piece of property, car, gun collection, whatever kind of stuff may go through the will. Well, instead of you owning those assets, you might put those things in the name of your revocable living trust, with the kids as the ultimate beneficiary. That means when you pass away, everything in that trust goes directly to the kids, avoiding probate. It does not avoid estate taxes, but it avoids probate. Some people say, well, Dan, I'm not ready to give my stuff away. Well, if you put the stuff in the name of your revocable living trust, you've not given it away because it's your trust. You decide to sell the house, you just sell it out of the trust. It's your trust. You buy a new one, you can put it in the trust if you want to. So if you put your stuff in the name of a revocable living trust, you've not given it away. You still own it. But when you die, immediately goes to the kids, avoiding probate. So a lot of people really like the idea of that. And be careful as I talk about avoiding probate. I've painted it as a pretty negative picture, and we'd probably like to avoid it if we can. And the way I kind of look at this is, and I don't have a revocable living trust. I'm kind of thinking about one for the reason I'm about to tell you about in a minute, but I'm not concerned about my heirs or my beneficiaries avoiding probate because I've got my life insurance, retirement plans. I mean, the bulk of my money is going to go to somebody avoiding probate immediately. And then if they have to spend a couple of hours with a lawyer, if they've got to make a couple of trips to the courthouse or something to get the rest of it, I don't care. Okay? And I'm being a little facetious with that, but I run into some people that, spend tons of money on trust to do everything perfect for the kids down the road. And if they're going to get this much money immediately, if they've got to work to get the rest of it over here, then I don't see anything wrong with that. So be careful about going just totally overboard to make stuff easy when maybe you got it real easy for a lot of stuff, and if they've got to do a little bit of work, maybe that's okay. All right. Now, the other reason why people do these revocable living trusts, and I read an article the other day, a perfect example. A husband and a wife had been very successful financially during their lifetime. And the husband had passed away, and Mama was kind of concerned about Alzheimer's and dementia, but what she was mostly concerned about was how her kids would manage her money if she did happen to get Alzheimer's. What she did was she put her assets in one of these revocable living trusts, and the kids are the ultimate beneficiary. And while she's in good shape, she is the trustee managing the assets. But when she gets Alzheimer's or dementia or whatever, then she has some trusted friends and advisors that will be the trustee managing the assets. And that means if the kids come in and say, well, we want some of that stuff, we want to sell some of Mama's stuff, the trustees say, sorry, you have no power over this. We're managing the assets according to your Mama's wishes. Now, when Mama dies, you'll get assets, but while she is alive, then we're managing by the trust. So that's the reason that a lot of people, so managing assets in the case of an incapacity. And with this Alzheimer's and dementia and all these things destroying a lot of people's lives, a lot of people are looking at that. I have just given you the impression that when you go to the lawyer to get your trust done, then in the lobby you'll see two piles of paper. And you choose from this trust or this trust. Trusts are kind of living, breathing animals, and the lawyer may design a trust that starts out as this type of trust and move to another. So it's a lot more complicated, but that's just kind of the two main categories there. All right, we talked about probate. Let's jump to guardians for the kids. I already mentioned you pass away, have young kids, you and your spouse pass, judge decides who will raise the kids. Then make sure that your grandkids are protected also. But there's generally two types of guardians. One, who's going to raise the kids on a day-to-day basis, take them back and forth to school, feed them, clothe them, raise them with the same moral values that you have. Then sometimes you have to think outside the box. Sometimes it's a real easy choice, my brother, my sister, something like that. But sometimes you got to think outside the box. I would always have a contingent guardian named. Have a second choice because something may happen that that initial person may not be able to serve as the guardian. So always have a second choice named out there. Then how do we handle the money for the kids? I guess the most dangerous way, and I see this fairly often, some people will leave all the money to the guardian for the kids. Understand how dangerous that is? I mean, even if they've got good intentions, and there could be lawsuits, divorces, things like that, probably the easiest way to do this is to set up a trust. And in a trust is your opportunity to manage the money from the grave. So you're going to specify that if I pass away, then I need a certain amount of money to go to the guardian for the kids to pay for their upkeep, food, and things like this. Maybe buy my son an old car when he gets 16, send him to a state university, pay tuition, room, and bills, give him some spending money. When he graduates college, maybe give him 25% of the money in the trust. At age 30, give him some more. At age 35, maybe give him the money left in the trust. But the trust is your opportunity to manage the money from the grave. You need to go into a fair amount of detail here. Some friends of mine asked me to be the trustee for their 3 kids should something happen to them. And I agreed to do it, and I talked several minutes about all the detail that needed to be in the trust. And then when they sent me a copy of the trust documents, I think it said, Dan, you know us, you know the kids, use your best judgment. And I called back and said, no, we talked about this. I need more detail than this. And they said, well, have we got to redo the trust? And I said, no, but write me a nice letter with all this stuff in it. And I got a letter with about 4 line items on it. But finally, they visited for the weekend, and we talked about each of the 3 kids. And their kids are different, and one of them is pretty much the perfect kid. I mean, if you gave this kid money, he would probably cure world hunger in about 30 days. I mean, he's just one of those kids. But then they got the other kid, Jake. And Jake's Jake's not a good kid, okay? I love Jake, okay? But Jake's not a good kid right now. I got about 4 pages for Jake, okay? I mean, we talked a lot about Jake because if I ever have to do this, Jake's going to be a nightmare to deal with. But I'm going to be able to say, no, Jake, here, your mom and I talked about this. Look, line 9, we talked about this. So go into a lot of detail on these trusts. Now, who will be the trustee for the money in the trust? Trustee is a person that manages the money and doles it out according to your wishes. Some people have the guardian for the kids as trustee for the money. Some people think that's a little too close. So if you've got a sister as guardian for the kids, you might have your mom and daddy and your brother or something like that as trustee for the money. But having another family member can be a problem. I mean, if granddaddy ever has to tell little Johnny you can't have money, then he's not the favorite granddaddy anymore. And in fact, he may be a little too flexible because he is the granddaddy. A lot of people use bank trust departments. I've got a cousin got a small trust from his grandfather administered by AmSouth Bank, I guess Regions Bank now. And when he needs money, he and his mama sit in front of a trust office, say, I need money. They say, what for? If he says this quarter's college, then they just read down the trust. Okay, line 4, college tuition, give me the bill, I'll pay it. But if he says, I desperately need 2 new red Corvettes, they just read the trust. I'm sorry, I don't see red Corvettes. I see 3-year-old gray Buick. Would you like that? But if he doesn't like that, then he can lay in the floor till closing time if he wants. So a lot of people like the idea of using bank trust departments. And, of course, that's not a free service, but it might be worth you calling your bank, ask for the trust department, and say, I'm trying to get my affairs in order. What do you charge for these types of services? Okay. Then, what's a personal representative? Another term for this is executor, but this is a person that carries out the wishes in your will. My wife is my executor. I am her executor. Should we both pass, we have a contingent executor. But it's a person that does the tax return, the estate tax return, gets everything toward probate, gets the kids to the guardian, sets up the trust. Pretty much the person that does everything. And who can be your executor? Don't hold me to this, but I think in Florida anybody can be an executor as long as they're a resident of Florida. But if you want somebody out of state, I think they have to be an immediate family member. And I think what I just said is right, but when you're going to the lawyer to get your wills done, be sure you're talking about where your executors live. Let me backtrack one thing on the trust. When I talked about setting up the trust for the kids, then you can set it up 2 ways. Some people right now will pay the money to have the trust written, and then when you pass away, all the money flow into the trust. But a lot of people don't do it that way. A lot of people have the trust in their will, which means the trust, you don't pay to have the trust done now. But in the will, it says, I want all the money to go to little Johnny and little Susie, but don't give it to them right now. Set up a trust. So the trust wouldn't exactly be written until you actually pass away. So that's the way most people do that, because obviously you think you're going to live a long time and you'd rather not spend the money to have a trust done right now if you may end up having to change it and things like that. So a lot of people in their will say, I want the trust set up. And that means you just don't have to spend the money and have that done, keep track of it, do tax returns and everything else. All right. After your will's prepared, keep it in a safe place. A lot of people keep their wills in their safe deposit boxes. Understand that could be a problem. I've got a box at a big bank and my name's on it, my wife's name's on it. We go in and out of that box independently. But if the bank finds out that I have died, they are going to shut that box down. And they're not going to let my wife in that box until she comes up with court administration papers. Now, my wife may be able to get in there before the bank finds out that I've died, but they do have people that check obituaries every day. So just understand, if you're wanting somebody to get in there, then the bank may shut that box down. And not all banks do it that way. I've actually got a box at a credit union, and they're real flexible. I think they'd probably let you in the box if you'd give them 6 months rent or something. I mean, I think they're more flexible with that. But next time you're at your bank or wherever your box is, go to the manager, not the teller, but go to one of the managers and say, what are the rules with this? Am I going to be able to get in there if my spouse passes away? But just make sure you know what those rules are. In most cases, there is one original to your will. But sometimes people might have multiple originals. And if you got 3 kids, some people say, well, just do me 3 originals. So every kid's got an original. The only problem with doing that, to be able to use the will, you've got to find all the originals, or it's a big hassle. That means most people have one original, and you know where that one is. Could be in your sister's safe deposit box. A lot of banks, no, not banks, a lot of attorneys have vaults where they'll keep the original of your will. And if you've got 3 kids and you're treating them all the same, then you may just make a Xerox copy and give everybody a copy and say, no secrets here. But make sure you know where that original is and it is safeguarded. But somebody's got to be able to get their hands on that thing quickly, because when you're being pronounced dead at the hospital, there's already people at your house taking stuff. Mama promised me this, Daddy promised me that. I mean, you see that stuff all the time. So make sure somebody can get their hands on that will. Everything I've talked about up to this point has been about having lawyers do your wills for you. Can you do your own will? And the answer to that is yes. You can get forms online. I think LegalZoom advertises on TV every 5 minutes. You could probably go to Office Depot and get forms out front. You can do your own will. Just be real careful with that. If you've got a simple situation, then chances are you could do your own will, but be real careful. There's specific rules about how it needs to be signed and wording and witnessed and all that kind of stuff. But for sure, if you just sit down and write something out and then sign it, the chances of it being legal and usable are slim to none. So be real careful about that. I've got a buddy that his mama did her own will, and I think 15 years later she ended up passing away, and Jerry realized that she had her will witnessed incorrectly. And he was put in a position of having to find 2 witnesses that he never knew and moved out of state years ago. We found one in Mississippi, one in Tennessee, had them sign some court affidavits, was able to use the will. But be real careful about that. Another source I think you have is, I'm relatively sure that the group life insurance provider for state employees, if you happen to be a state employee, I think that life insurance provider will give you some free legal services, and that would mean you could get a will, maybe at least a simple will, for free. Those of you that aren't state people, you might have an EAP program. I was at an agency last week. Their EAP program, Employee Assistance Program, gives a simple will for free. So look around. You may be able to find some sources like that. Then create a document locator. In those appendix pages in the back, there's something called a vital record keeper. Write down a better name. Write down Vital Records Organizer somewhere for me. Vital Records Organizer. And I want you to Google this, but this is a pretty neat deal. My financial life, let's see, I'm fairly well organized. Not perfect, but I'm fairly well organized. And I have pretty much my wife and I's full financial life in one big long file drawer. And I feel real good about that. But one time my wife said, well, if you die, is the easiest thing for me to do just start at the front of that drawer and work my way through it? Well, I didn't feel good about that. And my wife's not an idiot. I mean, she knows what's going on. She pays her bills. She does everything. So she's financially astute. In fact, if I needed to write a check, I couldn't without asking her to give me a check. So my wife knows what's going on, but she didn't really feel comfortable or kind of know where to start. So we came up with one of these Vital Records Organizer. It's about 6 or 8 pages long, But the first part of it is all the information on us: addresses, date of birth, social security numbers, everything. All that information on our kids, all that information on my mom that is under our care, then a list of the people that need to be notified if we pass away, a list of all our professionals, who does our taxes, who did our wills, all that kind of stuff, a list of our bank accounts, wherever we have money, list of all of our retirement accounts. It's got the information of who my wife should call at Ernst & Young about my company benefits, list of all our credit cards, list of all our insurance policies, list of all our life insurance policies, and the numbers and the toll-free number. But just on and on, all that kind of stuff. And what that means is if I passed away today, then my wife just goes and finds that one form. And that's all she needs to know to be able to function. And she could hand a page of that to one of her sisters and say, call those people, they need to know Dan died. And she could hand a list to another sister, say, call those life insurance companies, find out what we need to do to get the process started. So I feel good that I'm kind of organized, but I feel real good that I've got that Vital Records organizer, because that is real easy. And in fact, if my wife and I both die, then we've got my best friend as the contingent executor of our estate, and he has a copy of this also. My friend actually has this brown envelope that's sealed, and it's actually in a gun safe in his basement, so I feel pretty good about it being kind of safe there. I guess if people steal his guns, then I guess I'm in trouble too there. But it's got a copy of this thing. It's got a house key. It's got our alarm code. It has some of our computer passwords. I know it's against the law to write those down, but somehow or another you got to get computer passwords to somebody else. But if Stuart finds out that I've passed away, then he opens that envelope and he's got everything he needs to know to be able to process our estate, notify people, and things like that. But the one we've given you in these appendix pages, it isn't a bad one, but it's not great. But if you will Google Vital Records Organizer, you'll find a lot of them out there that are free, and a bunch of them where you can download them and actually fill them out on the computer instead of having to actually write them. But those things are real, real important, and I can't tell you how good I feel about being organized enough to have that. The next thing, set a date for a review. I think you should look at your wills and trust every year. My wife and I do it in December. I've got a little downtime. We're kind of thinking about family. We're starting to get tax stuff together, year-end statements coming in, and we just look at them. We don't take them back to lawyers to get them looked at. We just look through them to determine, has anything changed? And a couple of years ago, I guess we're looking through it, and it kind of reminded me that our contingent executor used to be an in-law that turned out to be an outlaw, so I had to make that change there. But I take a look at them every year, and particularly if you've gone through big changes, marriages, divorces, deaths, things like that. And particularly if you've gone through divorces, folks, please try and make sure you've changed all your beneficiary designations. I can't tell you how many times a year I run into somebody that tells me that maybe their brother just died and the evil ex gets the life insurance money instead of the current spouse with little bitty kids because he just forgot to change a beneficiary designation. I mean, literally, at least a dozen times a year, I hear those horror stories. So make sure you've changed everything. And if you've got sons or daughters recently divorced, sit down with them one day and just pin them down. Have you changed everything? Your life insurance, your benefits at work, everything like that, because the wrong person gets money all the time. So be careful with that. Then, taking care of survivors' needs. If you passed away today, then what would your survivors have? Your survivor may continue to work. The pension may throw some money in, Social Security, savings and investments, life insurance. These are those 4 pension payment options. And I'm not going through those again. I know Rich did a great job with that too, but just understand that when you retire, you have a choice of the four options. But remember, if you die before you retire, assuming you're vested, then you don't have an option. Your choice is number 3. So just understand your death benefits under that. Then under the investment plan, you're a little simpler. You just have a beneficiary assigned to your investment plan. You've grown that lump sum of money, and the money will go to anybody you like. Little kids, grown kids, a church, mom and daddy, a trust. So the investment plan is fairly flexible. And when you retire under the investment plan, some of you may end up changing it before you leave, but understand that's just a lump sum of money. You can leave that money in the investment plan if you wanted to. Continue to use those investments. Send me $1,000 a month, $2,000 a month. You can roll it to your deferred comp, roll it to an IRA. You can actually buy an annuity inside the FRS investment plan. So if you retire into the investment plan, or if you roll drop money to the investment plan, we have some people that take some of that money and buy an annuity with it. And that comes through your FRS investment plan. It is actually from MetLife. And if you are considering an annuity, understand I'm not suggesting you buy an annuity. But if you are going to buy an annuity with part of your money, you may want to take a look at this one inside the investment plan, because there's no sales charges in that thing, no agent's commissions. So you could say you're kind of buying that one wholesale. So again, I'm not suggesting you buy an annuity. I'm not even suggesting you buy this one. But if you are thinking about one, that one may be worth taking a look at. And particularly if you're just going to use it for planning, because if you go to an insurance agent and ask for an annuity calculation, they're going to worry you to death till you buy something. But you could call the guidance line and get the numbers, use that for planning, and then if you ever really decide to buy one, then you can go out and search the market and make sure you're getting what you want. But using it for planning could make a lot of sense. If you pass away in the line of duty, then they'll have a choice of, or you'll have a choice of paying it out under the regular pension rules, or for regular class people, the spouse would get half the member's monthly salary for life. And if there's no spouse, the kids would get a check until 18. They recently changed this for high-risk people. High-risk people, now it's 100% of the member's monthly salary for life. Under the investment plan, dying in the line of duty used to just give whatever's in the investment plan, and that is the case for regular class people, but high-risk people, they pay the benefit out under the pension dying in the line of duty, which means they would get 100% of the member's monthly salary for life. Social Security's out there. If you pass away, you leave a spouse behind that's caring for a young kid. If that kid or if that spouse is caring for kids under 16 or disabled before 22, then the spouse will get a benefit. The kids may get a benefit if they're under 18 or 19, still full-time, elementary or high school. Your spouse may be able to start getting a retirement check as early as 60 instead of waiting till 62. There may be a disabled widower's benefit. Parents' benefit, if you're caring for your parents and providing at least 51% of their income, when you pass away, there may be a parent's benefit, and there's a lump sum death benefit. Anybody remember how much that is? I think it's $255. Don't spend it all in one place. We don't have it listed on this slide here, but if you haven't set up your account on the Social Security website, remember, they used to send statements out every year by mail. They stopped doing that. Now they send statements once every 5 years. That's not often enough to look at your statement. But the website is ssa.gov, ssa.gov. Go out there, set up your PIN number, password to view that statement. I'd look at it at least once a year. Why is that? One, you just need to know what you might get under different scenarios. Two, it has your earnings history on it. That's what they calculate your benefits on. I have heard some people say they've seen some weird numbers on their earnings statement. It could be an indication of identity theft. Gives you another reason to take a look at those statements. And when you're calling the guidance line, a lot of those planners are considered very well versed in Social Security. While you're hitting them with FRS or other questions, hit them with those Social Security questions too. All right, medical treatment, handling personal affairs. 3 other documents that go along with the will. 1, a durable power of attorney. And this grants somebody the power to make financial decisions for you if you are incapacitated. If you have Alzheimer's or dementia, somebody can write a check, sell a piece of property, things like that. My wife has my durable power of attorney. I have her durable power of attorney. Then the living will. Living will states your wishes for medical treatment that you either do or do not want provided. Then the final one is your healthcare surrogate designation. This is your healthcare power of attorney. The durable power of attorney, already mentioned, is for financial decisions. The healthcare surrogate designation is for medical decisions. And so you need a living will and a healthcare surrogate. I think you do, because a living will won't be able to cover everything. There'll be some gray areas. You need somebody to negotiate with the doctors and the hospitals. And who should be your healthcare surrogate? I kind of kiddingly think you need to have the meanest rascal in the family. And I'm only half kidding about that, because the person that's got your healthcare surrogate may have to make some tough decisions. That may be somebody that says, that's Daddy, I love him more than life itself, but he wouldn't want this. So they're going to have to make some tough decisions. A lady a few months ago said, I've got my 2 daughters as my healthcare surrogate. I didn't like the idea of 2. I mean, whether it's daughters or sons, the idea of 2 of them kind of bothered me a little bit. All right, so who does all these roles? Let's see, my wife is my executor. Then my wife also has my durable power of attorney, and my wife has my health care surrogate. That means if I end up in an accident today and I'm in a coma, then she's making financial decisions because she has my durable power of attorney. But she's also making medical decisions because she's my health care surrogate. But if I pass away, those 2 powers lapse. But she will continue doing everything, but now her job description changes. Now she'll do that because she is the executor of my estate. And with mine, it's real easy. One person doing it all, but you may end up with different people. A lady the other day after a workshop came to me kind of worried, Dan, I got a problem. I just don't know how to solve my problem. Said, my son is my executor. He has my durable power of attorney, but he refuses to be my health care surrogate. And I had to ask why, and she said, he just doesn't want to have anything to do with having to make medical decisions for me. She said, I don't know what to do. And I said, well, it's pretty simple. You just have a third person. You just have somebody else do that job. So the son can do 2 out of 3, and then somebody else do the other. Okay. Now, where do you get these documents? Typically, the durable power of attorney kind of comes along with the will. They're almost a package deal. There'll be different documents. I think used to, durable powers came inside of a will, but now I think they're almost always independent. So those 2 almost come as a package deal. But you could easily go to the website or go Google a Florida-approved designation of healthcare surrogate and living will. You can print off the Florida-approved forms, and a lot of people go ahead and just do those on their own. And make sure you've got this durable power of attorney for your parents. If they're still around, then make sure you've got it on them because of Alzheimer's, dementia, things like that. I almost fouled this up with my mama. That when we kind of got an indication that my mama was starting to slip, I was starting to worry about this. I'd had mama's documents in my safe deposit box forever, but then when I pulled them out, didn't have a durable power of attorney. And I just can't tell you where it is. I know it was there, but it just vanished somehow. And I had to get another one. And if I had waited just a few more months before finding that out, I would have had a problem with that. but the durable power of attorney lets me manage my mama's affairs. Now, it's pretty simple because my mama has no money, but every once in a while I do have to write her name on something. So make sure you've got that durable power for your parents. That can also be a good way to start estate planning conversations with your mom and daddy, because you would like to know what they've done document-wise and stuff like this, but sometimes they think it's none of your business. But this durable power could be an easy way to start, that mom and daddy, we're getting our estate stuff in order, and we've learned about this durable power of attorney, and we're getting it for ourselves, and I just wanted to make sure you've got that taken care of. And then maybe your parents will open up and start talking about things, or could go the other way. It could be they look at you with this weird look and say, are you just trying to get my money? Is that what's going on? I mean, sometimes conversations happen like that. My mama was not great about communicating with stuff, but she talked to my Uncle Jim. So whenever I wanted mama to do something that I thought was a good idea, I'd go see Uncle Jim. And over a cup of coffee, if Uncle Jim thought it was a good idea, he wouldn't really talk about getting mama to do it. I'd just talk to him, Uncle Jim, I know this doesn't pertain to you, but I just thought this was interesting. And then about 2 days later, I'll get a call from Mama and say, Uncle Jim thinks I ought to do a durable power of attorney or something. Will you do that for me? Sure. He's smart, isn't he, kind of deal. So you just sometimes you just got to figure out how to communicate with your parents, but maybe they've got a lawyer or a family doctor or something like that. But make sure you've got those other documents. Let's talk about estate taxes. I mentioned this earlier. There's a free amount you can leave your kids and other people. Between a husband and wife, no estate tax. But there's a free limit you can leave the kids and other people. And not too many years ago, that free limit was only $600,000. I say only $600,000, but when you get a little money in retirement, you get a little life insurance, you get your house paid for, good many people had an estate tax problem when it was only $600,000. But now it's over $5 million, and most of us just don't have that problem. But you can use that $5.5 million while you're alive or when you pass away. And what do they add up to figure out what's in your estate? Everything you own. I mean, your property, your retirement accounts, life insurance, half of everything you own jointly, everything in those revocable trusts we talked about. Add it all up, that comes up to what's called your gross estate. You folks hate that term as much as I do. Couldn't they call it the he's trying real hard or he's working hard estate? Come on, y'all know that's funny. But so gross estate is everything you have minus what you owe, comes up to the adjusted gross estate. That's what they calculate the benefit on or the possible tax on. These people, Tom and Gail, everything they own is worth $415,000. That's their property, life insurance, and everything. If they died today, would they owe any estate taxes? Of course not. They're way, way under $5 million a person. Now, in addition to that $5.5 million that I said you could use when you die or while you're alive, you can also give everybody you know $14,000 a year. Okay, you could walk down the street giving out $14,000 checks. Give everybody a check you know, and it doesn't count against that $5.5 million. And this is probably one of those things that's a little outdated. But years ago, when the limit was only $600,000, a lot of people had an estate tax problem, and they would give everybody in the family checks every year on whatever the limit was that year. Might give the son, the son's wife, the 3 kids, my daughter, the daughter's husband, 3 kids, and then my wife would come behind and give everybody a check. So you're just trying to stay under that estate tax limit. But now people don't have this problem very much, so they're not using as much of this. But it's still out there if you need it. But what if I wrote my son a check for $20,000? Well, 14 of it was under this rule. The other $6,000, technically I owe gift or estate taxes on. But would I pay them? No. I would just apply it to my $5.5 million. That means if I die next year, the IRS would say, Dan can give away over $5 million. Has he already used part of it? and they'd say, yeah, he gave his son $6,000 too much earlier. And when we're talking about this tax, if you are giving money to, maybe your sister needs some money for an operation or something, maybe $25,000 for an operation, be sure and write the check directly to the hospital, and you wouldn't run afoul of this rule. If your kid needs $25,000 for college tuition, be sure and write the check directly to the school. Do you know the other reason not to write the kid the check? Okay, just wanted to make sure about that. All right. How do you find the right lawyer? If you need a lawyer to do your will, then you might need to find one that specializes in estate planning. There are a lot of lawyers out there, and I call them GPs, general practitioners. They may do a few wills, sue a few people, have kind of a general practice. And if you don't have a real complicated situation, you can probably use one of those. If you have a complicated situation, you may need one that specializes in estate planning. That probably means more costly. And how do you find a lawyer? Well, you could go to this Bar Association website that we've listed up there. You could go to the Yellow Pages here in Tallahassee. I wouldn't doubt you've got 100 pages of lawyers in the Yellow Pages. If you could find a set of Yellow Pages these days, I probably wouldn't look for a lawyer that way. I'd probably start asking my friends and family, do you have a lawyer that did your wills at reasonably priced and trustworthy? Most of your friends will say, I don't have a lawyer or will either one. But if you ask enough people, somebody will say, sure, I use Susan down here on the corner. I've known her forever, reasonably priced, trustworthy, but you can find one. After you find a lawyer, I would hit that bar website just to make sure that person is in good standing. Make sure you can communicate with that person. I've got 2 or 3 acquaintances that are, I think, very successful lawyers. I would never deal with them. We just talk a different language. I mean, I just don't communicate with them real well. And where's another place to find a lawyer? You may, as I mentioned earlier, if you're a state employee, I would check into that group life insurance provider, check your EAP program. If you're a union member or your spouse is union, sometimes a union benefit might be some legal services. I go to a mega church, and we've got lawyers in the church that give discount to church members. I used to be in Rotary Club. We had Rotary lawyers that gave discounts. So if you'll look around, military, if you're a retired military, decent chance you can get some services provided there. So look around for someone. Then what does it generally cost? Some lawyers charge by the document. They may say so much for a will, so much for a durable power of attorney. A lot of them charge by the hour. I had to have a trust done for my mama. I told you that my mama's in our care, and my mama has no money at all. And that means when my wife and I pass away, then our money will be used for my mama's care. And then after she dies, then we want the money going other places. And there was a couple other little weird deals in there too. And I had to call my friend Perry that's a lawyer and say, Perry, I got this problem. I don't know how to solve it. And he said, well, it's fairly simple. I'll just write a trust, and it'll say this, this, and this, and we'll get it taken care of. And I said, okay, well, what will this cost? And Perry charges by the hour. And if I remember right, I think he said charge $3.50 an hour to take 3 or 4 hours. So a lot of them just charge by the hour like that. It was kind of funny. A couple of years ago, a lady, when we were talking about lawyer costs, she held up some piece of paper and said, I've got my lawyer's menu right here. I, of course, had to ask her what she meant. She said when she was talking to the lawyer, said the lawyer met with her for free the first time. And then she said, okay, what does it cost? And he handed her this thing that looked like a plastic restaurant menu. And in it, it said simple will, so much. Will with a trust, so much. Durable power, so much. So she just said, give me one of those, and one of those. Call it her lawyer's menu. So that made a lot of sense. But don't do business with lawyers or CPAs without knowing what it's going to cost up front, because chances are there'll be a surprise at the end. And if you can't communicate with this person or something, then just find another one. I mean, it's not like they're hard to find. I mean, we'd probably throw a rock outside and hit 3 kind of thing, particularly in a city like Tallahassee. But find one you're comfortable with, communicate well with, and get along with pretty well. Let's see. Around to see if you can get some help. A great thing to do would be to try to start making some decisions as we've talked about here. And then you can call the guidance line and you can talk with them about some of these things. And our situations get fairly complicated. I mean, life's not as easy as it used to be, right? I mean, it used to be that we had a husband, we had a wife, 2.2 kids, and the station wagon, and a dog and a half, and everybody lived in the same town, and life used to be simple. But now it's my kids and her kids and our kids, and I don't want to do anything for that one. I mean, the house needs to go to this kid, and our situations are complicated these days. And if you've got any complications in your life, then that just means you've really got to do some work, because chances are things are not going to go the way that you would like for them to go. One thing I didn't mention earlier, I've mentioned sometime dying without a will. There's actually a word for that. It's called dying intestate. But I've always wondered why they have a term for dying without a will, because you can't die without a will. You have a choice. You can either do your own will, or you use the one the state of Florida has for you. And those are called the intestacy rules. But it's funny to me, there's a term for dying without a will when you can't die without a will. You get to use the Florida one or use your own. And if you don't have a will and you'd like to know what the one for Florida says, you can find that on flprobate.com. flprobate.com. These are the reasons we're here. Some things on your action plan. Get a will. Maybe update your will. Maybe look into that living trust type thing. Make sure you've got a durable power of attorney for you and your mom and daddy. Make sure your assets are titled properly. This one's real important. It is not uncommon to run into someone that's got a fair amount of money or assets, and they spent a pretty good amount of money getting complicated wills and trusts done, only to find out that they didn't title their property correctly to work through the documents. So when you get those wills and trusts done, I call it kind of a 2-stage process. Get all the documents and everything done, but before you walk out of that office, make sure, all right, my property, exactly how does it need to be titled to work with these papers? What do my beneficiaries need to be to work with these papers? So make sure everything is going to work together. Be careful, too, about leaving money to kids. We talked about leaving money to kids under 18, how that can be a problem, and I talked about trusts for that. But you can have trusts for older kids also, and that happens all the time. To tell you a funny story, in my neighborhood, there's 2 separate families that are not related at all. But there's women or in both these families that are in their 60s somewhere, and their final parent just died in both of these families. And both these women have been talking about the money that they're about to get, only to find out that their parents put the money in trust for both these women, and they're both getting monthly checks. And they're both mad at their dead mamas because the mama didn't give them the money, and they just can't figure out why their mamas treated them this way. And I'm trying to keep my mouth shut, but I know exactly why. One of these women is on, I don't know, her 4th or 5th husband, and this one is not a keeper either. So I think mama put it in trust to kind of protect that a little bit. And the other one never found a $20 bill she couldn't spend multiple times. If her mama gave her that money lump sum, that money would be gone in 6 months. So you can use these trusts for your older kids also. because you know if your kids have some little issues aside there, so nothing wrong with you trying to kind of manage that money a little bit from the grave. Resource-wise, please start wandering around at least a little bit on the website. Watch that hot topic box. If nothing else, all the forms and everything are out there. Then that phone number that shows up on those cards, and that's actually the last phone number you need to keep track of for the FRS. If you dial that number on the card and hit 1 or 2, you go to the EY planners. If you dial that number and hit option 3, you go to Rich's office. I think Rich probably gave you several phone numbers, but if you just want to remember this one, then you hit that. That goes to Rich's office. And then if you hit option 4, that goes to Aon Hewitt. They are the administrator of the investment plan. That means if you end up in the investment plan, or if you roll drop money to the investment plan, then Aon Hewitt, you'd call them to say, send me $1,000 a month, send me $2,000 a month, I want to change my investments, things like that. So that phone number's pretty neat. When you're calling the EY planners, there's a lot of ways to talk to them. You could just pick up the phone, call the number, say, give me to a planner. Or you could call the number and say, I want to schedule a time for a planner to call me. You could call and say, have a planner call me 2 weeks from Thursday, 4 o'clock in the afternoon at my home number, so my spouse and I can talk about this, 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 and this. You can actually go to the website. Top right-hand corner area, there's a chat button. So if you want to chat online with a planner, if you got a couple of simple questions, that is a wonderful way to get questions answered. Or you could say, have a planner call me 2 weeks from Friday. The second to last page in that handout has a text number. You can text in questions and get answers, or text in to have a planner call you. And then it's even got that little square scan deal if you know how to use that. That means if you're high tech, low tech, no tech, it doesn't matter. You've got a way to contact those planners. And then keep your eyes open for workshops in the future. We may be to your agency. If your agency doesn't have us come do workshops, then either call me or call the guidance line, and we'll be glad to come there, look at the schedule. We may be a block or two away from you. I think we've handled everything. And I don't think we've had questions as we're going through, so I think I'm going to close this off, if that's okay with Rich, and then I'll answer questions here. Is that right, Rich? Okay. All right. Those of you online, we enjoyed seeing you, and thank you very much.